I welcome on YourPedia, and this particular video is related to the third lecture of IPR, Intellectual Property Right, which is the syllabus in your upcoming exam of Examiner of Patent and Design, conducted by the body which is under Ministry of Commerce and Industry, and the body is Controller General of Patent, Design and Trademarks. So this is a very good job, and in my lecture I told you that these are some of the timelines for this particular exam. So if you have not filled this exam, still you have dates up to 4th of August. Pre will be on 3rd September, mains will be on 1st October, and then there will be interview, and 17th November result will be declared. YourPedia has made a wonderful module for this, and you can join team YourPedia and prepare really well for this particular exam. Now the topic which I am making, that is IP, Intellectual Property Right legislations in India, World Intellectual Property Organization, and in preliminary out of 150 questions, 15 questions will come from IPR. So this direct questions can be asked there, and in the mains there are two papers, paper 1, paper 2. Now in paper 1, out of 100 questions, 20 questions will be related to this. So I think this is 20 marks out of 100 marks will be related to this particular part. So 20 out of 100, that is again a significant portion. Now you can understand that IPR is giving you 10% in preliminary and 20% in paper 1 of mains. Paper 2 is separate. This is what it is. My today's lecture is about Indian Patent Act 1970. So this is one of the main, though amendments were there later on, this is the main act which deals with the patenting of the inventions in India. So there are some amendments later on, we will discuss that. So how do you define patent? And before I go forward, all these entire this content is available to you. You can download it from our website, you can see it, and this is a very good material for you to go through, and you can prepare it well with team YourPedia. So patent is exclusive right granted for invention, and it is given on product as well as process. You know what is product, you know what is process. So suppose I am making some particular thing on a machine. So machining is a process, and whatever I get out of that is a product. So process and product, patenting can be done on both. You can always have invention in the form of process, particular type of way. जिस तरीके से तुम कोई काम करते हो वो प्रोसेस है, वो भी तो न्यू इन्वेंशन हो सकता है. Patent is given on invention, something new which you identify or find. Something new which you find out can be process, it can be product, and patent is given on both. Exclusive right which is granted for invention actually, and it can be a way, the way you do the things, or new technological solution to something. किसी भी चीज को करने का नया तरीका या जो नई चीज तुमने बनाई उसके ऊपर पेटेंट दिया जा सकता है. Definition of the patent is this. Now there are certain important points which you need to remember about patent. First is, स्टार्टिंग तो हुई थी इंडिया में, हिस्ट्री अगर तुम देखोगे 1911 में, इंडियन पेटेंट एंड डिजाइन एक्ट 1911 केम व्हेन ब्रिटिश वर रूलिंग इंडिया. पेटेंट एक्ट 1970 इज द legislation which actually is being implemented now, and this came in force in 1972. तो स्टार्टिंग कहां से हुआ था 1911, और अभी कौन सा चल रहा है 1970. इंप्लीमेंट कब हुआ था 1972. कंट्रोलर जनरल ऑफ पेटेंट, डिजाइन एंड ट्रेडमार्क is the body which is responsible for this particular act. This body only is conducting this exam of examiner, patent and design. So this body actually is the responsible body for this particular act also. Headquarter कहाँ है patent office का, that is in Calcutta, but then there are some other branches also. National Institute of Intellectual Property Management, that also you should see, and that is in Nagpur. This exam mein this question can also come. National Institute of Intellectual Property Management, इसका office कहाँ है, ये institute कहाँ पे है, then you will say this is in Nagpur. And what is this office all about? This is a patent information system, so you should know about that also. Indian Patent Act 1970 was amended in 1999, 2002, 2005, 2006, so there were some amendments. Patent Act actually was amended for certain reasons, global reasons, or country national reasons. We will discuss about that also. Major amendment from where question can come in Indian Patent Act 1970. जो क्वेश्चन आ सकता है वो 2005 अमेंडमेंट से आ सकता है, दैट इज इंपॉर्टेंट एंड दैट इज व्हाट यू शुड डू. तो कब कौन सा एक्ट है, कहाँ पे उसका हेडक्वार्टर है, नागपुर में नेशनल इंस्टीट्यूट ऑफ इंटेलेक्चुअल प्रॉपर्टी मैनेजमेंट है, एंड ट्रिप्स क्या चीज है और पेटेंट अमेंडमेंट कब हुआ था. दीज आर इंपॉर्टेंट थिंग्स फॉर अस. नाउ कपल ऑफ थिंग्स विच यू शुड नो अबाउट 1970 एक्ट. Now, under this law, patent is granted for invention covering new process or product or any particular manufacturing commodity जो आपकी पेटेंट एलिजिबिलिटी को सेटिस्फाई करता है. पेटेंट हर चीज पे नहीं मिलता. इट इज नॉट दैट यू डिड समथिंग एंड आपको पेटेंट मिल जाएगा. पेटेंट प्रोसेस एंड प्रोडक्ट के ऊपर पेटेंट तभी मिलता है, यू विल गेट पेटेंट ओनली इफ इट सेटिस्फाइज सर्टेन कंडीशंस. व्हाट आर दोज कंडीशंस? वी नो दैट पेटेंट इज गिवन ऑन इन्वेंशन. Invention or nobility or creativity of certain type of process or product. Now that particular invention should be noble, that means new होना चाहिए, उसमें newness का concept होना चाहिए. If I ask you, if you say sir I want to get this patented, I will say what is new in this? Has anybody not done it before? You are the only one who is doing it. That is number one. Yes sir, this is something new. Second comes is it obvious? There are certain things जिसमें आपने कुछ भी नहीं किया. You have not done any effort. You only used your brain and you said okay, this is something which I told you. That was obvious. That was already there. Though you did not observe it, but it was already existing. Obvious. आप बोलते हो ना term obviously. So this is, you have not identified anything new. Like if you say sir I have identified something. I said what? The best your well-wisher in this world are your parents. Okay, obviously they are the best well-wishers, so something which already is existing, आपने कुछ भी आपने मेरे को बताया वो चीज, you told me that thing, maybe in the words you presented it, but it was obvious, it was naturally there. So have you put any effort in creating this? If you have not put any effort, it was already existing, it was naturally flowing, then it cannot be invention. You can't say this is invention, right? Now it must be useful in some kind of industrial setup. आपने जो इन्वेंशन किया ये यूज कहाँ पे होगा? Where will you use it in industries or something? If it is not used commercially viable, then you cannot get patent on that actually. So patent कब मिलता है? आपकी इन्वेंशन के ऊपर. अगर इन्वेंशन नहीं हो, पहले किसी ने ना किया हो, nobody has done earlier. Second, it should be you should have put some effort to create this invention. It should not be obvious. It should not be naturally existing. And third is it should be it should be bona fide in its manner. That means you should actually create something out of it. So ये तीन नाम आपने याद रखने हैं. एग्जाम में ये तीन चीज आएगा. तो इन्वेंशन 3 बेसिक टेस्ट होते हैं तभी आपको पेटेंट मिलता है. So I think this we have already covered. So patent आपका क्या है? Now some salient feature of this act I will discuss with you. Salient feature of Indian Patent Act 1970s are it is given on product as well as process. The time period of the patent is 20 years. Remember this also. Patent examination is conducted on request. You will always request, okay, this is a patent, please provide me this and please check it. There is fast track mechanism also. If there is a request from your side that I want this patent quickly, I want this immediately, this particular patent, then there is a fast track mechanism also. Pre-grant and post-grant opposition. If you want to oppose, somebody has filed patent and you want to oppose it, before he files, after his patent is granted, you can do that. Protection of biodiversity and traditional knowledge should be part of it. Somebody is doing patenting, so traditional knowledge should be protected in that. Publication of the application after 18 months of date of filing of the patent. You understand? So these are some of the dates, 20 years, 18 months, remember this. Direct question on the basis of this characteristics may come. Section 3 and Section 4 of Indian Patent Act 1970 is very important. याद रखना, Section 3 and Section 4 of Indian Patent Act 1970 says what you cannot patent. Section 3, Section 4 of Indian Patent Act 1970 tells you the things which you cannot patent, tells you the reasons or causes of not getting patented. So exclusivity, exclusion, excluded, you can't get with patent. So there should be patent subject. So there are certain patent subjects, innovations on particular subject matter. Subject matter is there. So something which is mentioned under section 3 and section 4, anything which is mentioned under section 3 and section 4 cannot be patented. It cannot be done. So section 3 and section 4 of Indian Patent Act list non-patentable subject matter. So when you see the list in section 3, section 4, something which is mentioned in that list means you cannot get patent on that. Novelty. So there should be some novelty, there should be some newness in that. There should not be any particular already existing technology, no invention or technology published in any document before the date of filing application anywhere in the country. That is another reason. If it is there, you cannot be given patent. So on these products you cannot get patent list mein. On if already existing, then you cannot be given patent. That is another reason. And steps non-clarity, if it is not very clearly mentioned, right? If the things are not very clearly defined, then also patent cannot be given. So characteristic of an invention that involves technological advancement and economic importance compared to already existing knowledge only can be patented. So what is the criteria of patenting? You come out with something in which there is a technological breakthrough which was not done earlier, which can eventually give you economic benefit. That only can be patented. Listen this carefully. Patent can only be given if you have done something, you have invented something, whether process or product, in which technological advancement is reflected. You have made something, technology, philosophy nahi chalega. Technological advancement should be involved so that it eventually leads to growth of economy, commercialization, something like that. So वो चीज आपका ये है. अगर if it should not be it says that invention should not be obvious to a person skilled within the same field where invention takes place. It should not be obviously it is there. I have done nothing. If I ask you आपको patent चाहिए, आपने किया क्या है, what you have done? Say I have not done anything, but I am suggesting something new. I mean it was there but nobody identified it. I am telling you this. तो आपको patent नहीं मिलता. Capable of industrial application. I told you, I mean you should have a patent जिसका industrial application हो. तो ये 4 points याद रख लेना. This section 3, section 4 is telling you these are the reasons why you may not be given patent. Just remember this, read these things. Now there are some sections other than section 3, section 4 which are important of Indian Patent Act 1970. Exam में तुम्हें पता होना चाहिए. Section 84 to 92 talks about compulsory license. Compulsory license. So, and license is given for 20 years, right? Section 85 to 92 are related to compulsory licensing things only. So though patent gives the exclusive right to the person who gets the patent, so third person cannot use it unless until government or controller of patenting intervenes and provides the compulsory license of producing the things under certain situations, right? National emergency is one of the situations. I give you example. COVID आया, suppose some pharma company says I have patent of this medicine and this medicine may be used in during COVID. Now government can use compulsory license clause to tell other companies to use this patent knowledge and make the medicines for national interest for emergency situation. That is called compulsory license. Compulsory license government has also used to distribute medicines to other countries. Like India distributed a lot of medicines to some other countries also during COVID. So government can use compulsory license as a clause to allow other companies who do not have patent to use this technology to make a product which is required under emergency situation. So compulsory license का clause 84 से 92 के बीच में है, and that is something which is very very important. This compulsory licensing helps public to afford medicine at affordable prices, and developing countries में इसका बहुत benefit होता है. Now what is section 100 of Indian Patent Act 1970? It gives the power to central government to use invention for purpose of government. So government obviously will take care of people. Government is for welfare of the people. So if government wants to use some patent for welfare of people, then under section 100 it can use it. 104 to 114 क्या है? patent infringement. It talks about patent infringement. So no suit of infringement can be brought before a court inferior to district court. So that is what is mentioned in Indian Patent Act 1970 under clause 104 to 114. So what is 104 to 114? That is patent infringement. That is what is this. Okay, so infringement can be of two types, direct infringement and indirect infringement. And indirect infringement is called doctrine of equivalent. Indirect infringement is doctrine of equivalent. Direct infringement, indirect infringement. Direct infringement is when product is, close to the patenter product and it is being used by somebody else. That is the direct infringement. Indirect infringement or doctrine of equivalent occurs when each element is identical to the infringing device, and this is also called literal infringement. So this is basically not the product is directly not infringed, but some kind of element is basically infringed. So this is basically it falls under triple test, that means equivalence holds when elements perform the same function in the same way. So अगर infringement direct product के ऊपर, suppose you say okay this product is similar to my product, then you say directly infringement. Indirect infringement means indirectly तुम छुपाने की try करो, you are trying to hide something, but elements and all it is visible that you are trying to infringe. Directly infringed, it is clearly yes you have made the same thing. Indirect infringement means it is not clearly visible, but your intention is to infringe only. Some elements are being used the similar way. So section 104 to 114 is used for that. Remember, doctrine of equivalence is basically used for indirect patenting, and that is also called indirect infringement, literal infringement, indirect infringement, doctrine of equivalence. These all terms you should be aware. Section 159 of Indian Patent Act 1970. So this gives the power, this tells the power of central government to make the rules which empower government to propose change in this particular thing. So power of central government basically by which it can change the rules of Indian Patent Act and it can amend, basically amending power. So central government only will make the rules, right? So any change in the Patent Act, because Parliament makes it, so that section 159 will give the power to central government to make some rules. So what is the summary of Indian Patent Act 1970? Now it came into force 1972 and it was amended in couple of years, and the first amendment came in 1999, and it was related to exclusive marketing right. That was the first amendment act, but the most important amendment act was 2005. 1994 India joined World Trade Organization and hence it also became the signatory of Trade Related Intellectual Property System, TRIPS. So 1994 May India became part of it, and then India to have compliance with WTO, World Trade Organization, Intellectual Property Right Act 1970 was amended, and the main amendment was 2005, which allowed pharmaceutical companies to go for product patenting and prevent patent evergreening. Patent evergreening क्या होता है, that it is also secondary patenting. It is like if I have a patent, then I give further right, I mean somebody else is again making patent on the same thing, similar thing. मैंने पेटेंट बनाया है, मेरी ही टेक्नोलॉजी को थोड़ा सा चेंज करके तुम दोबारा पेटेंटिंग कर रहे हो, that is called patent evergreening, so that is secondary patent. Listen this carefully. I have already made a patent and now you are changing little bit the technology, which I suggested, you are changing it and making another patent. So same patent pe another patent cannot be made. If it is done, it is called patent evergreening. So 2005 में pharmaceutical patent, basically pharmaceutical field में lot of changes were suggested, and it also prevented the patent evergreening. So 2005 was very, very important amendment act, and you should basically go through it properly. Number one, it gave the product patent protection to pharmaceutical, food and drugs. Earlier process patenting was there. Process के ऊपर patenting was already existing on pharma and all, but 2005 amendment gave product patenting also, like you can patent the product also, not only process but product also. And term of protection will be for 20 years. It was now said it is 20 years. And also compulsory license for export of medicines to different countries. That also was amendment 2005. So grant of compulsory license for export of medicine. So remember, most important amendment of Patent Act is 2005. What were the things there? Product patenting was given to pharmaceutical companies. What else? It was said that it will be given for 20 years. What else? Compulsory license grant was given to some, for export of medicine to the countries where it is to be done. So that was in accordance with Doha Declaration of TRIPS, because 1994 में we joined WTO and then accordingly compliance was there. इसका इफेक्ट क्या हुआ? What was the effect of this Patent Amendment Act 2005? That drugs, cheap price पे drugs मिलना start हुआ. Compulsory licensing helped to check the cost of the drugs, right? And also Indian drug companies became competitive at multinational level. I mean global level पे they become competitive, and multinational companies के साथ they could compete. And generic drugs, I mean those drugs which are to be used for public, they should not be very costly. Like COVID के time पे बहुत महंगी drugs दोगे, poor fellow cannot use it. So generic drugs could be produced after that at the affordable price. Why? Because it was possible then. MNC could open research and development centers in India. So what were the various effects of Patent Amendment Act 2005? Number one, actually it helped the drugs cost and all to be within particular price. The exorbitant price were prevented. Compulsory licensing thing helped in that. Our drug companies became competitive, and MNCs started opening R&D centers in India, and Indian pharmaceutical companies, they started flourishing in our country because they found this particular regime to be better. I mean they could compete at the global level. So these were some of the effects of Patent Amendment Act. Pharmaceutical and biotech patents, So section 3 specifies the inventions that are not patentable. So but this pharmaceutical and biotechnology are not in that category. They are registered now in India, but after lot of examination, stringent examination process. So new substance, whenever it is to be done, whenever it is a pharmaceutical or biotechnology related patent, section 3 is very carefully seen. Why? Because section 3 mentions the products and processes which cannot be patented, and when it comes to pharma and biotech, then you are maximum cautious to see something which should not be by mistake made patent, something like that. Provision of patent law allows patenting of product in chemical, biotechnology, food processing and all, not just in process but product also. So as I told you, 2005 Patenting Amendment Act the main outcome of 2005 Amendment Act 1970 Patent Act was like product patenting was permitted. Product patenting can be done. So that was done in biotechnology, chemical, food. So earlier it was there in other industries, but now it was done in pharma sector also. Okay, so rights granted by patent, it can be given for process, it can be given for product. So process you already know, I mean you cannot, if you are granted for process, nobody can use that process, and if it is granted for product, then the product cannot be, the same product cannot be used. Whether you use the different process, but same product you cannot make, something like that. So this is the two kind of patent we have. Term is for 20 years from date of filing the patent application. So 20 years from when the patent is granted to you or when you file the patent application. So see this carefully, right? So this is term of patent. Now let's see some kind of questions if we can make. So patents are applicable for what? I mean for what you can make the patent. Patent is always filed for new innovation or new invention. It is given for product, it is given for service. That is how it is given. Which legislation is mainly used related to patents in India? So it is Indian Patent Act 1970. Which of the following is not used as one of the criteria to file patent? C, invention must be notified within a year. That is not as a criteria. So what is the criteria? it should be noble, it should be non-obvious, and it should be bona fide matter. Bona fide matter. I mean, it should be done in useful. The invention should be useful. Patent is granted for how much period? It is granted for 20 years. Which of the following is not the feature of Indian patent? Term is 20 years, not 15 but 20 years. Indian patent can be product, process, fast track is there, opposition can be pre and post grant. Which of the following is not a type of patent? I mean, process is not a type of patent. यूटिलिटी पेटेंट होता है, डिजाइन पेटेंट होता है, प्लांट पेटेंट होता है, प्रोसेस पेटेंट नहीं होता. पेटेंट इज गिवन ऑन प्रोसेस एंड ऑन प्रोडक्ट, बट टाइप नहीं है वो, इट इज नॉट अ टाइप. Right, so with this we come to an end of this particular lecture, which was Indian Patent Act 1970. Let me tell you, in your syllabus there are a couple of small things, important things. Just revise all the things, because 15 questions will come in pre and 20 questions will come in the mains from this. And in 2015 and 2018 Patent Act में से your intellectual property right में से question नहीं आया था. This time it is going to come. So prepare it really well, so that you are confident to solve the questions when it comes and you get the job of examiner, patent and design. All the very best. Thank you.